Okay, let's unpack this. Picture a scenario that feels like it's, ripped right out of a heist movie. You help a friend plan a robbery. You're the logistics person. Maybe you're even the one who actually goes out and buys the gun. You hand it to them. You get in the car. You drive to the scene. But then, right before the moment of truth, maybe you see a security guard. Maybe you just get a pit in your stomach. You get cold feet. You panic. You open the car door and you run away into the night. You're gone. 5 minutes later, your friend pulls that trigger. Here is the question that keeps law students awake at night. Are you off the hook because you left? Or are you just as guilty of murder as the person holding the weapon?
It's a terrifying question, isn't it? And most people, if you ask them on the street, would instinctively say, well, I left. I wasn't there. I didn't pull the trigger.
Of course.
But the law has a very different and much colder perspective on what it takes to wash your hands of a crime you helped set in motion.
Exactly. And that brings us to today's deep dive. We are unpacking a specific, high-stakes legal concept called the doctrine of renunciation. And to do it, we aren't just looking at textbook definitions. We are looking at it through the lens of a heavy-hitting case from the Connecticut Supreme Court in 1993, State v. Adams.
This case is fascinating because it forces us to confront the difference between a moral change of heart and an actual legal defense. It's all about the difference between running away from a crime and, actually undoing the damage.
So before we get into the gritty details of the Adams case, and trust me, the details are tragic, what is our mission for this deep dive? How are we breaking this down?
I think we have a clear analytical path today. First, we need to set the stage by defining the strict doctrine of renunciation. Under the Connecticut statute and the model penal code, we need to know the rules of the game.
Right.
Second, I want to use, let's say, a very visceral hypothetical to help you understand a key concept called depriving aid of effectiveness.
Depriving aid of effectiveness. That sounds technical, but I have a feeling it's the pivot point of the whole discussion.
It's the absolute linchpin. If you don't get that phrase, you don't get this defense, period. Third, we're going to perform a rigorous FIRAC and elemental analysis of State v. Adams. We'll dissect why the defendant's claim that he fled the scene wasn't enough to even get a jury instruction on the defense.
And finally,
to wrap it all up, we'll synthesize a diagnostic checklist. If you're a law student, this is for exam prep. If you're just a curious listener, this is so you can spot this issue a mile away.
perfect. But before we dive into renunciation, we probably need to take a half step back. We're talking about being guilty for a crime someone else committed. That's accessorial liability, right?
Right, that is the baseline. Under the law, if you aid, abet, or encourage a crime, you are just as guilty as the principal actor. You and the shooter are, in the eyes of the court, one and the same. Renunciation is your escape hatch. It's what's known as an affirmative defense.
Okay, so I'm already on the hook for murder because I bought the gun. Now I want out. What exactly is renunciation in a legal sense? Is it just changing your mind?
No, it is significantly more than that. I mean, the general rule is that renunciation requires you to admit you helped, but then claim you shouldn't be liable because of your later actions. But this defense is extremely narrow. It requires much, much more than a mere change of heart or just flight from the scene.
So if I just run away, that's not enough.
What are the specific boxes I have to check?
There are three primary elements to this rule, and you have to hit all of them. First is desistance. The defendant has to stop participating in the crime.
That seems obvious. You can't renounce the crime while you're still holding the bag right now.
Exactly. That's the easy part. The second element is active rejection. The defendant must completely and voluntarily renounce the criminal purpose.
Voluntarily seems like the key word there. It is critical. You can't just stop because you hear police sirens or because, the victim turns out to be a black belt in karate. That's not renunciation. That's just self-preservation. It has to be a genuine voluntary rejection of the criminal plan itself.
Okay, so stop participating and truly mean it. What is the third one?
The third is the most difficult, and it's where most of these defenses fail. It's called depriving effectiveness. The defendant has to perform an act that wholly deprives their prior system of its effectiveness in the commission of the offense.
Can we drill down on that? Wholly deprives effectiveness. What does that actually look like in practice?
It means you have to undo the help you gave. Think of it like a chemical reaction. You added an ingredient, a catalyst. To renounce, you can't just walk out of the lab. You have to reach into the beaker and remove that catalyst before the explosion happens. If you provided materials like a weapon, a key, or a map, you have to reacquire them or somehow neutralize them. You cannot leave your contribution on the table.
That is a significantly higher bar than just I quit.
Yeah,
You have to effectively checkmate your own prior assistance.
precisely.
Before we apply this to the Adams case, I want to make sure we really get this concept. It feels counterintuitive. If I leave, I'm not helping anymore. Why does the law demand I go back and undo it?
Because the law cares about the result, not just your feelings. If your help, that gun you bought, is still being used to kill someone, your contribution is still effective. Let's use a hypothetical. I call this one the poisoned chalice.
I'm listening. Lay it out.
Imagine you are the accomplice. You hand the principal actor a cup of poison, intending for them to give it to a victim. You have provided the aid, the weapon itself.
Okay, I've handed over the poison. The clock is ticking.
Now, consider scenario A, ineffective renunciation. You hand over the cup, but then you feel this massive wave of guilt. You think, I can't do this.
Yeah.
You turn around, walk out of the building, and go home to pray. 10 minutes later, the principal feeds the poison to the victim. The victim dies. Are you guilty of murder?
My gut says, maybe. I mean, I wasn't there. But based on your definition of effectiveness, the poison I provided was the cause of death, so yes.
Correct. You are guilty. Walking away did not stop the poison. Your aid, the cup, remained effective regardless of your geographic location. You left the weapon in play.
Okay, so how do I get out of it? What's the right way to do it?
Scenario B, effective renunciation. You feel that same guilt. But this time, instead of leaving, you run over to the principal and you slap the cup out of their hand, shattering it on the floor before the victim can drink.
That's dramatic.
It has to be. Look at the result. You have wholly deprived your prior act of its effectiveness. The weapon is gone. The aid is neutralized. That is renunciation.
That makes it crystal clear. You have to slap the cup out of their hand. You can't just leave the room. It's about stopping the mechanism you created.
Exactly. And that is the lens we need to use when we look at State v. Adams.
All right, let's go to the real world. New Haven, Connecticut. This is a 1993 Supreme Court case, but the crime happened a few years earlier. Let's analyze State v. Adams. First, what are the legal dispositive facts?
Let's set the scene. It's April 1990. The defendant is Shelton Adams, Jr. He is with a man named Sherman Sims. They go to a neighbor named Roberts, and they acquire a .38 caliber handgun. That is the first critical fact. Adams helps get the gun.
So the weapon is in play, and Adams was part of securing it. What happens next?
At 2:48 in the morning, Adams and Sims call a taxi. The victim is a driver named Alan Hansen. He picks them up. Now, the seating arrangement is important here. Adams and Sims are in the back seat. Sims is sitting directly behind the driver. As they are driving, Sims orders the victim to pull over.
This is the moment everything goes wrong.
Yes. Sims pulls out that .38 caliber gun, places it against the victim's neck, and fires. Alan Hansen dies almost immediately. They then drag his body out of the car and rob him. Later, Adams is seen wrapping Sims's hand, which was injured during the shooting. And crucially, they go to the Mill River and dump the gun, which was later recovered by police.
Okay, those are the prosecution's facts.
Yeah.
That sounds like a straightforward felony murder case.
Mm.
But Adams had a defense, right? He didn't just sit there and say, I did it.
And this is the pivot point for our episode. Adams gave a statement to a detective. He admitted he was in the cab. He didn't deny that. But he claimed that he didn't know Sims was planning to rob the driver right then. He claimed that when the cab stopped and Sims pulled out the silver handgun, Adams opened the door and ran away before the shot was fired.
So his argument is, I bailed out before the murder happened. He's banking on that I wasn't their defense we talked about in the intro.
Correct. He claimed he heard the gunshot when he was about a block and a half away. In his mind, he had disassociated himself from the crime.
So the trial happens. Adams wants the judge to tell the jury, hey, if you believe Adams ran away, you can find him not guilty based on renunciation. But the judge refused.
Right. He requested a jury instruction on the affirmative defense of renunciation, and the trial court denied it.
And what was the core legal issue?
The precise legal issue was this. Did the trial court make a mistake in refusing to instruct the jury on the affirmative defense of renunciation? Basically, did Adams present enough evidence to even let the jury consider the question?
That's an important distinction for our listeners. The judge didn't say Adams is guilty. The judge said, Adams, your story is so weak legally that we aren't even going to let the jury discuss whether it counts as renunciation.
Exactly. It's a gatekeeping function. If the facts don't fit the legal criteria, even in the best light for the defendant, the defense doesn't get the instruction.
So, to decide if the judge was right, the Supreme Court had to look at the rule. What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court applied Connecticut General Statutes Section 53A10, which tracks with the Model Penal Code. For a defendant to get this instruction, they need to show evidence of two distinct things. First, complete and voluntary renunciation. This means a total rejection of the criminal purpose, not just postponing it, not just getting scared. And second, and this is the critical element, neutralization of aid. The rule states that if the defendant previously aided, for example, by supplying arms, they must take steps to wholly deprive that aid of its effectiveness prior to the crime's commission.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, the requirement for an evidentiary foundation?
Okay, so here we need to look at a sub-rule from a case called State v. Bell. The sub-rule is that a defendant is entitled to a defense instruction if there is any evidence in the record, even if it is weak, even if it is incredible, even if the judge personally thinks it's a lie.
So the bar is incredibly low. If there's just a sliver of evidence, the jury should get to decide.
Very low. But, and this is a huge but, the evidence has to actually support the legal elements of the defense. You can have a mountain of evidence that you ran away, but if running away isn't the legal standard, it doesn't matter. The court applied this by asking, does Adams's story of fleeing the cab actually meet the definition of renunciation?
Understood. Now, what about the second element, the requirement to deprive aid of effectiveness? This seems to be where Adams's defense crashed and burned.
This is the heart of the case, so let's do a mini IRAC on just this element. The sub-issue is whether running away from the immediate scene constitutes depriving the aid of effectiveness when that aid was a weapon.
And the rule on that?
The sub-rule regarding weapons is very specific. The court held that when the prior aid consists of providing a weapon, mere flight or a statement of withdrawal is insufficient per se. The accomplice has to retrieve the weapon or dispose of it or warn the police to thwart the crime.
Insufficient per se. That's lawyer speak for it never counts. How did the court apply that to the facts Adams presented?
Well, let's look at the application. The state's theory of liability was that Adams procured the gun for Sims. That was his contribution, his aid. Now, look at Adams's defense. What was his act of renunciation? He ran away. He did not take the gun back. He did not warn the driver, Mr. Hansen. He did not call the police.
So going back to our poison chalice, he essentially just walked out of the room while Sims was still holding the cup.
Precisely. And that is the conclusion on this element. Merely leaving the scene did not neutralize the effectiveness of providing the gun. The gun remained with Sims. That specific gun was used to kill the victim. Therefore, the aid was still effective. The element was not met.
And after analyzing all the elements, what was the court's final conclusion?
The Supreme Court affirmed the conviction. They held that because Adams failed to provide an evidentiary foundation that he neutralized his assistance, specifically the gun, the trial court was absolutely correct to refuse the renunciation instruction. He didn't get to argue it to the jury because his facts just didn't support the legal standard.
That is a harsh but very clear lesson in accessorial liability. It really highlights that once you start the ball rolling on a crime, the law makes it very hard to stop it. Responsibility is sticky.
It is. It places the burden of undoing the harm squarely on the accomplice. You created the risk. You have to be the one to eliminate it.
So this brings us to the practical part of the deep dive. We have a lot of law students listening or people who just want to understand how to analyze these situations. If I'm looking at a fact pattern, how do I know if renunciation applies?
Okay, let's synthesize this into a diagnostic checklist. We can call it the Adams checklist for renunciation. If you are on an exam or just analyzing a news story, go through these 5 steps.
Okay, hit me. Step 1.
Step 1. Identify the accessorial act. You have to ask, what did the defendant do to get in trouble in the first place? Did they provide a gun, a map, a code, or just encouragement? In Adams, it was providing the gun. You have to know what you are renouncing before you can renounce it.
Okay. Identify the aid. Step 2.
Step 2. Check for mere flight. Did they just run away? If the answer is yes, you can pretty much stop there. That's a fail. Flight is not renunciation. It might prove you're a coward, but it doesn't prove you're innocent in the eyes of the law.
That's the trap. Don't fall for the I ran away defense. Step 3.
Step 3. Apply the neutralization test. This is the big one. Did they take specific affirmative action to undo their specific help? The remedy has to match the aid.
So if I gave a gun, I need to take the gun back.
Right. If you planned the route or gave the security code, did you warn the police or the victim so that the code no longer works? You have to actively intervene.
Got it. Step 4.
Step 4. Verify timing. Did this happen before the crime was committed? It's too late to renounce after the bullet is fired. You can't renounce a murder that has already happened. That's just called remorse.
Finally.
Step 5. Conclusion. If the aid remains effective despite the defendant's absence, there is no renunciation defense. End of story.
That is incredibly helpful. It cuts right through the noise. It's not about how bad you feel, it's about whether you stopped the mechanism you helped build.
Exactly. The law demands action, not just a change of heart.
This has been a really enlightening look at State v. Adams. The big takeaway for me is that the law views a conspiracy or an accomplice scenario almost like a physical machine. If you built a part of the machine, you are responsible for what that machine does until you dismantle your part.
That is the perfect summary. And actually, if I may add one final thought, there is a really provocative nuance the court touched on that we shouldn't skip.
Please go ahead.
The court noted that the statute requires you to deprive the aid of effectiveness. In Adams, that was physically possible. He could have, in theory, taken the gun back, but consider this. The court suggested that some acts of assistance might be impossible to renounce.
Impossible, like what?
Think about information. If I give you a physical key to a bank vault, I can take the key back. I've neutralized my aid. But what if I tell you the memorized combination to the vault?
I see where you're going. I can't reach into your brain and take the numbers back. I can't make you unknow it.
Exactly. Once the words leave your mouth, the aid is effective. Even if I call the police, if you get to the vault before they do, my aid, the code, was still effective. So this raises a deeply fascinating philosophical question. If you provide information that cannot be forgotten, have you crossed a point of no return the moment you speak?
That is terrifying. It implies that for certain crimes involving information hacking, corporate espionage, planning renunciation might be legally impossible simply because the human brain can't be neutralized.
It's a distinct and chilling possibility. Once the genie's out of the bottle, maybe you can't put it back in.
That is a heavy thought to leave us with. Be careful what you say, because you might own the consequences forever. Thank you so much for this analysis.
My pleasure.
And thank you for listening to this deep dive into State v. Adams. We'll catch you on the next one.